Hello, my name is Andrew and welcome to another Chill with TFC episode. In this series, we talk to interesting people with relevant experience and insights to help us learn from their perspectives so that we can create the life we love and manage our finances well. Today, we're going to find out what does a property lawyer do when you are buying a house in Singapore. Conveyancing is a legal step that every property owner needs to know. My guest is a legal associate at Apex Law. She advises clients on conveyancing matters and helps them to understand the whole process of their property transactions. In our conversation, she shares her legal knowledge using examples and layman terms. Let's welcome Hui Yu. So in property buying or selling, we keep hearing this term called conveyancing.
Correct.
Can you explain to us what does it mean?
Okay, so conveyancing is actually the umbrella term in law. Conveyancing law is for us to handle all property transactions. So the conveyance of land, that's where it starts from lah. So when you transfer land or any property over to someone else, that's the meaning of conveyance.
Okay, so the transfer of a property in this case, me transferring to you. Okay, so today we're going to talk about buying property specifically. So what does a lawyer do in the whole process of buying a property? How does a lawyer help me?
Okay, so I understand many of you, when you want to buy a property, you are fixed on, okay, I want this property. You head down, maybe you have an agent, maybe you don't. You head down, view the property, and then you sign your option to purchase. And then that's when things get interesting because you need a legal service to come in and assist you to complete this transaction. So for our firm, we do help our clients to simplify the process so that their only worry is to pay the balance purchase price. So that will be at the end. When they walk in, they can just have the keys and then they head to their new home. But behind the scenes, actually, the lawyers are doing a lot of work. So these are the parts where it's not seen by the common layman. So what we actually do is, say, for example, drafting of all the legal documents. Even for HDB properties, there are a lot of legal documents involved. When you take a loan, we also add for your bank. We also help the bank to disburse the monies. So whatever money that you are taking from the bank actually have to go through some checks first on the property. Then the bank will decide they can lend you the money.
Isn't it quite a standard process though? Whether it's a new launch or it's a resale. I mean, maybe for a resale, the terms, you have to look at it carefully.
Yes.
But for a new launch, it shouldn't be quite standard from my understanding?
So yes, the sale and purchase agreement for new launches are actually governed by the rules. So they don't vary much. But what you will see is that there's a lot of special annexures actually added on to each sale. So even though if you see the transaction is almost about the same, there's always these few clauses that come across. There's always special conditions that are tied to each specific transaction. So even for each client who come in, we do have to have a one-on-one meeting, sit down with them, go through with them all their documents, and advise them on all the special conditions that come in. So even if you are buying a HDB, there are also special circumstances that are tied to each purchase. Even say, for example, maybe their seller have requested for an extension of stay. Maybe the buyer have applied for a grant. We will advise our clients accordingly. People will come in, apply for BTO. Well, if lucky, then they get. Yeah. Okay. Then towards the end, towards the key collection part, that's when the lawyers come in. And why the lawyers are required is usually because you are taking a bank loan. So for bank loans, we do have to come in and then help you to disburse the monies, help you to arrange for how much you are using from your CPF as well. Then we'll advise you on what's the balance you are still paying from your own cash, from your own pocket lah.
Okay, so what a lawyer does in this case, okay, we're talking about a new launch HDB BTO, right?
Correct.
So you're helping us in the relationship between me, let's say me, I'm the buyer, and then there's the bank.
Correct.
And then there's HDB itself, because I'm buying from HDB.
Yes.
Earlier on you mentioned there are some annexes which are different. So
that one is more for private property.
That one's more for private.
Correct.
Okay.
For HDB, they do have it standard. You know, your HDB all built is around the same lah. Each HDB, maybe the facilities a bit different, but still roughly HDB rules are all the same. For private condominiums, however, that's where the difference comes in. So for private condominiums, when it's built by private developers, they may have many different rules and regulations on how they want their whole condominium to look. So HDB very standard.
You can repeat that sentence
okay.
again. Yeah.
So instead of HDB.
Okay.
So HDB very standard is they have their roofs, windows all the same. Yeah, you can't change
Is it true
lah.
that HDBs all look the same nowadays? When I go to a friend's new place. Like,
Yeah, the
Okay.
video all look the same.
You can say that because you're a lawyer. If I'm talking to an agent, okay, maybe different story.
As in, of course, your own renovations, that's how you personalize it.
Yeah.
That's your internal. So you
That's
can
right.
personalize it afterwards.
Understand.
Of
Understand.
course.
Okay, so we've spoken about private property and then about a new launch BTO. How about a resale then?
Okay, so resale, right? Usually there's a contract. So for HDB resale, your option to purchase is also standardized. You do have to go to HDB website and then download the exact HDB option to purchase. They'll give you a serial number that's tied to you. And you have to get this approved by HDB. So that's how it's actually different from private. So from private condominiums, right, you do need the lawyer involved because each option to purchase, although nowadays there's standard templates, but the agreement between buyer and seller is more, you can agree on different items, different terms. So for example, extension of stay, HDB only allows for 3 months. You have to agree and then apply for it and apply for HDB's approval.
Extension of stay referring to...
Okay, sorry. So extension of stay comes in when your legal completion is on a certain date. For example, tomorrow, you are completing the sale or purchase of your property. However, the sellers have yet to find a place to move to. So the sellers say, okay, can you please give me maybe another 3 more months to stay in before I can move to my new place. So even though you have paid the monies over, you are the legal owner, your sellers who are supposed to move out will stay on for another 3 months. So for HDB, it's standardized, only 3 months. They can't go longer than 3 months. Whereas for private property, you can do as and when you wish.
Oh,
So
okay.
you can just agree accordingly. You can even charge a rental amount.
Oh, it can be stated in the contract.
Yes, so this can be stated in the contract. You can negotiate with the seller and then you can get the lawyer to come in and then draft the letters to actually confirm it in writing. So there's more freedom in negotiating for private properties lah, in this sense.
Okay, so what other differences are there for a resale? It seems like there's a lot more things to
okay.
look out for.
Yes, so for private property, because it's not built by HDB contractors, so private properties, we do have to do our searches more thoroughly. There are what we call legal requisitions. So this
Requisitions.
yes.
Okay. Is it REQUISITION?
Yes,
And what does that
correct.
mean? It's search for information.
So these are a set of questions that we will send in to government authorities. So when developers build the property, they do have to get approval from government authorities like Building and Construction Authority. So these are the searches that the buyers don't see lah, but this is what the lawyers are doing behind the scenes. So for condominiums, we will ensure that the whole property is in order. Any additions or any alterations to the condos are also in order. There is approval given. So we'll make sure all these checks are there.
Okay. So just to make sure I get it right, so we talk about the differences between, let's say, the first example was BTO. So it's more, in a way, more straightforward because it's with HDB and you're managing the relationship with HDB. And then, of course, there's the bank loan part. You manage the relationship with the bank for the client. And then there's the private property.
Yes.
And then, so for private property, you really have to look at the annexures. That's what you call it. And because every property developers might have certain things that they want to put into the contract. So that's where the lawyer can help you sort out the information that's in the annexure.
Correct.
Okay. And then after that, we move into resale. And of course, resale itself, there's also HDB and private
Yes.
property. But generally, the idea is that for a resale of a private property, there are certain terms that you can negotiate further. For example, the extension of stay. And then,
yes.
but for a resale in HDB, it's maximum 3 months.
Correct.
Okay. Any other differences that we should know about between these 3 categories?
Okay, so the main few are between the HDB and the private. So for private, when they are managed by MCST as well, when it's a resale, we will also get a certificate from them to say that this property is in order. So the next difference, I guess, is when you speak about, because nowadays it's condominiums, but there are some who are buying landed properties. So landed properties will be the next set that will be slightly different. And of course, because the value of landed properties is much higher, you take on more risk when you're buying a landed property. The rules governing landed properties are also slightly different. The approvals they are getting have to be checked more thoroughly as well.
Okay,
So that would be the next set after condominium, I suppose.
Right? So for landed property, is it open to a lot more flexibility?
That will be the same for private condominiums because they are still contracts. So in a sense, although this is for conveyancing, it's still tied to a contract between the buyer and the seller.
Okay. So could you give an example of how different it might be for a landed property in this case?
For one is that landed properties, you are not able to buy it if you are a foreigner. You do have to receive special approval from the LDAU. Yeah, so there's special approval from government because they don't allow foreigners to
So
buy
there's
it.
a government body that you have to get
Correct.
approval from. So it's a Singapore law,
Yes,
essentially.
it's a Singapore
Okay.
law. Yeah. Then for landed property, usually because the price is higher, we will want to make sure your rights are protected. One instance in which maybe one of the questions for a common maybe dispute lah, for example, was a client came in and she told me that there's a huge tree in the backyard which she wants it removed.
Okay.
Because when it comes to landed property, you have gardens, and then the gardening cost is actually quite high. So there was a tree in the backyard, and she wanted it removed, and so she asked me. The seller said they will remove it, but legally, what are my rights to this tree? So that's why we
Who
actually
owns the tree?
it is owned by the owner, so
Okay,
it's
okay.
in the land. It is fixed to the floor. So actually, in property transactions, there's this meaning that you buy the property with vacant possession. So when you buy the property with vacant possession, it means as it comes, you have all the fixtures in the property. Any furniture in the property should usually be removed.
Okay, so
Yes.
vacant, the definition is like it's all empty,
It's
right?
empty.
But in this
So,
case, it means the fixtures are have to be there, of course. But
correct.
the seller could remove all the furniture.
Correct.
Okay.
Yes. So this is also subject to agreement. I mean, the starting point, there's always a starting legal point, but it's always say subject to your agreement. So for this tree, actually legally, it should be recognized as a fixture because it's grown into your ground. So that's a fixture. It's not something that's
Oh.
easily removable.
Okay.
But after that, she clarified and said, no, it's not in the ground, it's in the pot. So that's when it's a very
Okay,
minute
okay.
difference,
Definitions.
but it's a difference. So
Okay.
if it's in a pot, then yes, the seller have the obligation to remove it from the property.
Oh, this client could become a lawyer. She's got potential. She's trying to understand the definitions and
Yes,
therefore
correct.
trying to protect her rights as well.
Correct.
Making sure that she gets what she wants at the end of the transaction.
Yes.
Okay.
So our job as lawyers is to make sure when at the end of the transaction you are getting what you want. But in the meantime, because we are always standing by the line of the law, you are underground. So how we advise you is, okay, so on the ground you see this, you see the tree there, this is your legal rights to it, this is what you can do, what you can tell the seller to do as well.
Okay. That's more of an interesting story. Do you have horror stories that you have to
Horror
resolve for
stories.
your clients?
Okay.
Really difficult cases.
So disputes between clients lah. Usually this comes in also same concept here is usually for clients what they see is when they go into the house they see something that comes as an unpleasant shock to them. So one case that happened was that when the client went in, they actually saw that the countertop was removed.
So that's a fixture, right?
Yes, so
Countertop
see,
fixture. Yeah, okay.
Yeah, so the definition is the difference is very minute, but it is there. So any countertops, any kitchen cabinet, for example, those are considered fixtures. Whereas if it's a table, a standalone table, for example, your dining table that's not built in, there's a furniture lah. So that one, if the seller removes it, then it's fine. But in this case, it was a countertop. Yeah, so buyer went in and got a shock.
Right. So your client, the buyer in this case,
Yes.
The buyer needs to fight for the rights.
Rights, yes.
right, to get back the countertop.
To get back the
Okay.
countertop. Yes, correct. So because when they sold the property, it actually comes with this countertop.
Did they like the countertop so much that they removed it and moved it to a new house? Like, why would you remove the countertop?
That I can't say because we did not communicate with the
Okay,
seller.
okay,
I can't tell
understand.
you why the countertop was removed.
Yeah, it
But
must have been a
possibly-
really nice countertop.
Yes. I mean nowadays
Marble,
when you look
something.
at this kind of fixtures, it's actually expensive.
Okay.
Yeah.
Right. So that's I'm assuming that's a private property, right?
Yes, it's a private property.
I see. So you have to resolve it for your client.
Correct.
Did the buyer get back the countertop at the end?
Okay.
Just curious.
So for the disputes cases, because for our conveyancing process is up to the legal completion. So when there's a dispute, right, you do have to engage the lawyers to again help you in the dispute to get back the countertop.
Legal completion. In this case, what does it mean?
Okay, legal completion means we get the title deeds to you. You are legally recognized as the owner, and also you have the keys and access to the property.
Okay, so it is only at that point in time the buyer found that the countertop is missing.
Correct.
So if I found that the countertop was missing before this legal completion, then I could, what do you call it?
Yes.
Raise a
Okay.
dispute.
So when we raise the dispute, in that case, we still help our client to write into the seller because we want to wrap up nicely. But with litigation and disputes, there are always additional costs. So we did help the buyer to write in to the seller's law firm and say that this is missing.
Okay.
And yes,
okay.
and afterwards, I think they actually went on to privately settle the matter.
But because in this case, I as the buyer, I found out only after the legal completion, I have to kind of raise it as a new case again
Yes,
to get
correct.
it resolved. And in this case, it was resolved privately eventually.
Correct.
Okay. So should there be like a checklist of things to hand over for a resale?
Okay. So this is something the buyers can consider. So when you first go and view the property, the option to purchase sometimes will say that there's an inventory list. So you can consider having this inventory list being annexed to the option to purchase so that this will help you in the future when there's any disputes lah.
We also have this inventory list for new launches.
New launches usually comes
Do we?
with the sale and purchase agreement. Inventory list, sometimes yes, new launches may come with say washing machine or say not microwave, mostly oven lah. Yeah, maybe a built-in oven. Yeah, so all these specifications will actually be in the sale and purchase agreement. They will actually even specify the type of flooring that will be provided, the type of finishing that will be provided. All this is in your sale and purchase agreement.
Okay. So what I understand so far is that there's a lot of work that lawyers do behind the scene, but we don't really get to see them. Is it true that a lot of first-time home buyers especially, right, they just leave it to the lawyers because all this legal stuff is too complicated for me?
Yes, okay. Yeah. So yes, for us, we also still try to simplify the process as much as possible because we want our clients to experience a process that's fast-free, that's very for them is very straightforward. We try to avoid all these disputes. So on our end, we check in, but when there are disputes, we do raise it up to the clients because they do have to be informed. So as far as possible, we balance it lah. Even though sometimes our clients come in, okay, I just want to pay and get my key. Then we'll, okay, but we have to settle you down. We have to explain to you
Okay.
and in layman terms, let you know what you are going through in this process.
So it's part of a lawyer's duty to sit down with the client and explain the all the terms within the contract, right?
Correct.
And I have to sit down with you and listen to the whole conversation so that I know what's going on.
Yes, so at least the buyer is informed of all these risks and say what is going to happen during these few months. So we inform our buyers of this, we give them advice, but on the buyer's end is we try to simplify it so they don't have to do anything lah, basically.
Okay. How much is legal fees? Could you give a range?
Okay, so legal fees will depend on whether it's a HDB or whether it's a private property. So because as explained just now, the legal process is quite different. We do have more extensive searches for private properties. So it will actually range in at 2,000 onwards lah. Usually that is the case around there. Because there's quite a few disbursements that we have to come up with. So actually our legal fees, even though we do at 2,000, from that 2,000, there's payments being made to IRAS. That's for stamp duties for mortgage. So one thing funny is that a lot of clients don't know about this, but when you take up a loan, when you take a mortgage, even if it's for a HDB loan, you're actually paying $500 to IRAS for stamp fees.
So the stamp fee is $500.
Yes.
But it's not paid to the law firm. You're just getting the money for the stamp fees, right? Okay.
Yes, so we help our clients to process all these as well. So that's also one important part of the lawyer's job is to ensure that you pay the correct stamp duties.
Okay. So it ranges from 2,000 onwards, depending on how complicated the whole process is.
Yes.
Okay. You mentioned buyer's stamp duty, so tell us about it.
Okay, so buyer's stamp duty is a fee that every buyer have to pay when they are purchasing a property, regardless of whether it's HDB or it's private. So the range for private residential and HDB residential property only. Notice the focus on residential lah. So actually this amount is only for residential properties, not for commercial or industrial properties. So for residential properties, for the first 180,000 of your purchase is at 1%. Next 180 100,000 is at 2%, and then the third 180 is at 3%. Then from there on is at 4% onwards. So if you go online, you can actually Google buyer stamp duty, IRAS, and they have a calculator for you. You can enter your details and the property price, and then they'll be able to tell you the buyer stamp duty. But in additional to this buyer stamp duty, there's a second part, which is additional buyer stamp duty.
There we go.
Yes.
That's why it's called additional.
Correct.
Okay.
So the rates just now were the normal ones. So everyone buying, regardless of your citizenship, for even Singapore citizens, you have to pay the normal buyer stamp duty. For additional buyer stamp duty is usually for Singapore permanent residents and also for foreigners and for Singapore citizens who are buying their second property. So for example, you already have your first HDB and you're thinking about buying your second condo as an investment plan. Maybe you want to rent out a second property, but you want to continue staying in your HDB. In this case, when you come to us to purchase a second property, we will advise you accordingly. For Singapore citizens purchasing their second property, there's an additional buyer stamp duty of 12% of the purchase price, market value. Okay, so this one we will let them know during our meeting how much actually they are supposed to pay lah.
Okay, so it's also part of the lawyer's duty to let the
Correct.
buyer know about the additional buyer stamp duty.
Correct.
And to make sure that, of course, we can afford it, right, and not be
Yes.
shocked.
Correct.
Okay, so it
Yeah.
seems like at different stages, there'll be something to pay. For example, stamp duties,
Correct.
there'll be the initial deposit, and then the monthly, the mortgage loan, of course. So, and then you mentioned disbursements just now. So could you
Okay.
talk a bit about that and what's the whole
Okay.
process and how is the lawyer still involved in this process?
Okay, so for disbursements, let's start off from that. When I mention disbursements, right, it simply means the giving out of money.
Okay,
So-
yeah.
so,
I can see my money going out to pay for the property.
Yes,
Yeah,
correct.
money going out, disbursement.
Yes, correct.
Okay.
Okay, so at the start of the stage, so this may be the other part that's different for HDB and for condominiums. So for private properties, like maybe we start with that. When you first get your option, you pay a first 1% deposit. When the option is being exercised, you need to pay a 4% deposit. Then thereafter, you have to pay your buyer stamp duty within 14 days when you exercise the option.
Okay.
Then you have a completion date, which is usually fixed for 8 to 12 weeks after the exercise of option. The completion date is when you pay your balance amount that is still due after you have used up your bank loan and your CPF amount.
Okay.
So for example, you buy a property at $1 million, you first pay 10,000 lah at the start. When you first feel, okay, I want to buy the property.
Right.
Then the seller say, okay, so in exchange, you need to give me 10,000 first, then I'll give you this option. Then you can come back and decide later if you want to continue.
Okay.
Okay, then once you continue, you pay a 40,000. This process, we actually assist our clients to help them to pay over the 4% deposit to the seller's law firm.
Okay. So 10,000 is to get the OTP and 40,000 is to exercise the OTP.
Yes.
Right, 1% and then 4%. after
Correct.
that.
That's
Okay.
the usual rates lah. Because it's a private
Oh,
contract, they
using 1
can
million as the
yes,
amount. Okay.
as the amount.
Got it.
That's just as an example.
Yeah, easier to work with numbers.
Yes. Yeah. So sometimes there may be different varying amount also. They may say, oh, I need a 2% first, then you can pay me 3% later.
Oh, okay. It need not
But
be
that's
1%.
a common. Yes, that's common.
Oh, okay. Okay.
So the 1 and 4 is the most common one that most sellers use. But if the buyer and seller agree otherwise, so this is where the freedom to negotiate comes in.
Okay.
So if they agree otherwise, they can write down in writing, say how much they want to pay upfront.
I can change the 4% too to exercise the OTP?
Sure.
Okay, but usually it cannot differ too widely, right?
Usually the
Are there
buyer
cases
won't
whereby
want to pay too much
much, right?
upfront as well.
Unnecessarily.
Yes,
Yeah,
correct.
okay,
So
okay.
that's the standard procedure lah.
Okay, so the seller could possibly ask for 2% for the initial.
And then 3% later.
Okay. So that still makes it 5%.
Still makes it 5 lah.
Okay, so this part is still negotiable. Well, and you mentioned you have 14 days to exercise the OTP. Well, previously I've been reading articles where it used to be 14 days, but there are cases whereby the buyers can extend it and it's being clamped down.
Okay.
Could you tell me a bit more about that?
So that is actually the clampdown is for new launches. So for new launches, right? Previously, what new launches were doing is they issue an OTP. The OTP will expire within 3 weeks, And then when it expires, the developer will just say that, we are giving you another chance. We are extending this option to you. So another refresh of another 3 weeks.
Okay.
For example.
A new 3 weeks, for
Yes.
example. Okay.
So now the government has stepped in. So this is where government regulations may come into play. Even though it's a private contract between developer and buyer, the government regulations have come in to say that no, this option reissuing is not allowed.
Okay, so this is called an OTP reissue.
Yes,
Right.
correct.
So I'm just guessing, on the ground, let's say I'm the buyer and I need cash flow. So maybe, I couldn't pay it within the 3 weeks, and therefore a lot of people, some people are doing it, and therefore I do
Yes.
it as well. But this kind of inflates the situation because like people are maybe buying more properties, and therefore the government has their own policies to
Yes.
come into place to make sure that this doesn't happen. Right?
Yes,
and
so that's
overinflate
where
the property market too much.
Yes, correct. So that's where the government authorities have stepped in, but that's for new launches.
Right.
So for
Okay.
a purchase of a resale, the expiry of the option has not been regulated yet.
Oh, okay.
So if you are purchasing it from a seller in the market, in the open market, your option expiry date, common procedure is still 3 weeks or sometimes 2 weeks, but that is agreement between buyer and seller. So they can set in by a certain date you need to exercise the option.
Could it go more than 3 weeks?
Yes,
It's
definitely.
possible. So it's all an agreement between the both of
Correct, there's
them.
an agreement.
buyer and
The
the seller.
government so far has only stepped in for new launches,
New launches.
with developers.
Okay, got it. So can you help me understand regarding ownership? Let's talk
sure.
about ownership. Well, there's ownership of the property, and then there's ownership of the mortgage loan itself. Tell
okay.
me about it.
Okay, so in a sense, it's not an ownership of the mortgage loan, but more when you apply for a bank loan. Say you are applying, most of the time you purchase this with your spouse. So both you and your spouse are legal owners of the property. However, when it comes to the bank loan, when you went to the bank, they will actually assess your income. You decide that only one party wants to be the borrower of the loan, and the other party usually will stand as a surety.
Oh, okay. So is it a definite case whereby only one party can, what do you call it?
A
Be-
borrower.
Borrower can be the
Yes.
borrower. You can't have two borrowers?
You can have two borrowers as
Okay.
well. This is actually more tied into the buyer's own financial planning as to whether how their income is being structured, who do they want to stand in as the borrower.
Understand, because if I'm a single borrower, you're looking only at my income, and let's say
Correct.
my income is higher than my spouse, then I want to get a higher loan, so I will just be a single borrower. But if I have two borrowers, that means me and my spouse in this case,
Correct.
the bank will look at both our incomes, right?
Yes,
and
correct.
therefore, let's say the spouse is earning lower, and the bank will not lend out as much. Is that correct?
No, actually they will look at the combined income if
Combined
you
income.
have two borrowers. Yes.
Okay.
But different banks have their own criteria. So that's why some people, when you go to a banker, they will actually assess it, and then you can get your letter of offer in order.
Okay, what is the advantages or disadvantages of single borrower or two borrowers though?
Okay, not so much as of an advantage or disadvantage. It's more for financial planning.
Okay.
Okay. So say you are the sole borrower of this housing loan, and your partner is standing in as surety. That actually clears
a surety.
surety.
How
Yes.
do I spell it?
SURETY.
SURETY. What's the role of the surety?
Basically, it just means that if you are still a mortgagor, so you are still an owner of the property. For this loan, you are still being tied into it in a sense, even though you are not stated as a borrower.
Okay.
You still have your liabilities under this
Okay.
loan as well.
You're just not the borrower.
Yeah,
but
you're just
still
not the
related.
main borrower.
Okay,
Correct.
got it.
So in that case, right, it actually frees up the second person's credit facilities.
Then the second person can borrow other things, right? Maybe
Yes,
a car loan
correct.
or
So
something. Okay.
yes, that's where it comes in lah.
I see. Okay.
Don't use surety this word.
Don't
Because only one bank is using.
DBS.
So what's
Call
the...
it a mortgagor non-borrower.
okay,
Okay
got
lah.
it.
Mortgagor non-borrower.
Got it.
Or you can say just a borrower or non-borrower.
Can.
Yeah, try not to use surety because it's very inclined to only one bank.
You want to
Yeah, but
repeat
we
this
use-
part?
Okay,
Cause-
sure.
cause,
But we always use DBS, so sorry.
working
Use
with DBS more.
When you say surety, right, it has become very inclined to one bank and it's a bit biased.
Okay.
Yeah, so
sure.
because
Understand.
it's an open talk, so we got to go to an angle where
Right.
Yeah.
Okay. You want to repeat the whole part again?
Where shall we start from?
Let me maybe I ask you the question.
Sure.
Okay, so there could be a case where there's one borrower, and what is the role of the other party?
Okay. So the other person is just seen as a non-borrower. So even though he owns the property, he is not borrowing directly from the bank to make the purchase of this property. So he will still be tied into this loan lah, in a sense. But for him, his credit facilities is more freed up.
Okay, so the other spouse in this case can be free to borrow other things for car loan or
Correct.
what have you, right? Okay, so there's the borrower and a
Non-borrower.
non-borrower. Okay, but wow, Choi, because both the spouse own the
Yes.
property, right? But what happens if something happens to them and they want to divorce, and then the loan is it belongs to the borrower, right? The borrower has the responsibility to repay the loans, right? The non-borrower in this case doesn't have the legal liability. Is that true?
They will still have the liability there because they are still the owner of the property.
Okay.
When the property is not being paid, meaning your monthly installments are not being paid on time, the bank will still foreclosure the property, meaning they will sell it and then they will redeem back the loan, whatever, how much it is outstanding. So in the case of a divorce, what happens usually is that there's a transfer of this matrimonial home. There will be a court order that will have to go through. So for that, right, what will happen is the couple, if they have already married and they bought this home in joint names, they will go to the divorce lawyers to get their court orders in place. So depending on whether it's contested or non-contested, they will have a finalized agreement to say what happens to this property. So even if only one person is the sole borrower, the property in this sense will still be dealt as a matrimonial home.
Okay. Okay. I think my key takeaway for this part of the conversation is that there's a difference between owning the property and being the borrower of the
correct.
mortgage loan in this case. So the ownership structure for the property itself, it can be between two names, the spouses, but the borrower can be one person. So
Correct.
there's a difference between these two. We just have to know
Yes.
that there's a difference between these two. Well, are there cases whereby, let me think of another examples other than spouse. Let's say the child owns the property, but the mortgage loan, the borrower is a family member. Is that possible? But
okay.
the family member might or might not live in the house.
Okay,
You get
so
what I'm trying
that's
to say?
actually against MAS rules.
Ah,
So
okay.
if
Okay.
say you are borrowing, so say you're purchasing this property in your child's name. And
Yeah,
as
because I'm
the
a parent. I love my
parent-
child. I will support him or her all the way. I will
Yes.
pay the bank. But he or she can live alone there.
So in that sense, if you still want to borrow from the bank, right, the borrowing must still be done in the child's name.
Okay.
You cannot
on
have
my own,
a-
I can give my child money, but
Yes,
but
yes.
my child must be the person who is borrowing.
Borrowing from the
Okay.
bank, yes.
Okay.
So in this scenario, sometimes if say the parents wants to buy a property for their child, so that will be slightly different. We do have some cases who parents come in, they want to buy the property for their child. They will not be taking up a bank loan. So what they do is they actually pay for the property in full cash, and there's a trust deed for their child.
Okay, tell me a bit more about that. So I have to pay in full? Is it a choice
correct.
or that's
Yes,
what
it's
usually
a
happens?
choice.
Okay.
Yes, it's a choice because if say you are a parent and you want to purchase the property on your child's name directly, but at the moment your child does not have the financial capability to pay for the property,
Okay.
so as the parent, what you can do is say you can buy it for them.
In cash, in full.
In cash,
Because
yes,
the
it
child
has to be in full cash.
The child could have just started working and therefore
Correct.
might not be able to borrow that much.
But
Okay.
only if say the child is below 21 as well, like as a minor.
okay,
That's
okay.
one of the transactions that we do see. So but for those cases, you can't do a borrowing on behalf of your child. So that's against the rules lah.
Okay, so your child has to be the borrower. In
Correct.
other words, okay. So, let's talk about the ownership of the property itself. I believe it's not 50-50 all the time, right?
Yes. Okay, so ownership of a property between two or more members, there's actually two different kinds. So the first kind will be a joint tenant. So joint tenants, right, they hold the property jointly. Just now you mentioned 50-50. So many people think that joint tenants means 50-50. Actually, conceptually, that's a bit skewed. So for joint tenants, they actually hold the property as a single share together. So that
Two people sharing 100% together.
yes,
Is that the way of saying it?
Yes,
Okay,
you don't say that 50-50 lah. Although
there is also no 70-30. There's only
that
100% and two of us share the 100%.
correct, that's for joint tenants.
Joint tenants. Okay.
So for joint tenants, that is the way, and there's a right of survivorship. So right of survivorship actually means when one owner passes on, the remaining owner, they will still hold on to the full 100%
Okay.
directly.
Okay.
So even if say one owner wills the property away to a third party, maybe they want to will it to another family member, that's actually not possible if you're a joint tenant. The remaining owner will always have the first right to the property.
Okay, and this also includes cases whereby, let's say, there are 3 joint owners, joint tenants.
Yes, even if you have 3 joint tenants, the
One
one
person
person
passes
passes
away.
on, then the other remaining 2 will just come in and take the whole property.
Okay.
So because they don't actually have a distinct share of the property, you don't split it down the line.
Okay, so it's not a distinct share.
Yes,
okay, it's just
correct.
100% shared by whoever is
Yes,
remaining, and this
correct.
is called right of survivorship.
The right of survivorship is the passing on to
passing on.
surviving owners.
Okay.
So the term for this is joint tenants lah. You hold this 100% together.
Okay.
So the other way is actually tenants in common. So tenants in common will be what you have suggested. There will be 50%, 50%, 30%, 70%. So this one is a bit more distinct. You actually come in and say, okay, I own 30%, you own 70%. We draw a line where we own it.
Is this decided in advance by the parties involved?
Yes, so during our meeting with our clients, we will advise our clients on this, and then they can tell us which one they want to go for.
Okay. I understand.
So for tenants in common, there is no right of survivorship. So this means whenever one owner passes on, whatever share they are holding, be it 30% or 70%, or even that 50%, it will pass on according to their will or the interstate law.
Okay. Okay. You'll be according to the estate. You'll be part of the estate.
Yes, it will be part
Okay.
of the estate,
Got
just
it.
that percentage itself.
Okay. So 2 of them. Anything else? Joint tenancy and
Tenants in common, that's
right?
the only 2 ways you
Okay,
can
this is
split.
the ownership. So
the
usually if
ownership
you
of
think
the
about
property.
50-50, that's actually part of the tenants in common, under the tenants in common arrangements. Okay, but you need to take a look at this ownership structure. It could be joint tenancy.
Yes,
right?
correct.
And therefore it's not really a 50-50. It's not distinct.
Correct.
Okay. Okay. So in terms of buying property, getting legal help, anything that you want to remind us about before we wrap up this part of the conversation? Thank you for watching this video. If you found it useful, like, share, subscribe, and feel free to leave your comments. You can also join our Telegram group, follow us on social media, and sign up for our weekly newsletter. Everything is in the description. For more content, check out thefinancialcoconut.com.